All right. And here we go. In 3, 2. Well, hello and welcome into New York's Asset Protection Roundtable, a 3 pillars of protection program. I'm Ben George alongside Ted Alatsis over at the Alatsis Law Firm there in Brooklyn, New York. Ted, welcome in. How are you today?
I'm great, Ben. Hope you're doing well.
Yeah, no complaints. No complaints at all. And I'm looking forward to our conversation today. We're talking about when and how to challenge or attack an estate plan. And I guess, when I think about it, I know you work on this every day, but for someone that doesn't think much about estate planning day to day, right? I don't really think about the challenging aspect of things, right? I kind of think like you build it, you set it, it's in place, and then it just kind of holds strong and sturdy. But I guess there are times when you do have the opportunity potentially to want to challenge an estate plan.
Yeah, that's true. And, when you're planning, you need to think about, being defensive of something like that. So yeah, absolutely. It happens more often than you would think.
Yeah, that's a good point. The defensive side of that too. So we're going to take you through just some various ways that you can challenge, maybe undo, override an estate plan and the circumstances around when this might be appropriate. If you have questions for Ted, you can always find him online at latzislawfirm.com. You can also jot down this number as well, 718-233-2903 to call and set up a time to meet with Ted. Let's start off, Ted, I guess, the reasons why you might be suspicious of an estate plan. I guess, what would be some of the circumstances or some of the reasons why you might raise a red flag or two?
Well, I think at the end of the day, it always starts with the documents themselves and what's contained in them, right? So, there are, certain things that become a red flag, certainly if you're a potential beneficiary or someone who, would ordinarily be receiving a part of an estate if a person didn't have a will, and you see that suddenly you've been cut out, then, well, that certainly could raise some suspicions. And then, then at that point, you need to think about what and how the documents were executed and what manner they were executed, and then look at the different things that could raise suspicions with regards to the procedures that were undertaken in terms of making those documents a reality.
When I say like on this list of things that could raise a suspicion, without a document properly executed, is that something that's easy for someone that isn't familiar with this process to pick out and be aware of?
Not necessarily. I mean, at the end of the day, it really depends on the type of mistake or error or documentation that's been put into place. And so some things are a little bit more obvious than others. Handwriting, that can be something that could be obvious to someone who knows the handwriting of the person who signed a document. But, other infractions may not be so obvious.
Okay. And I know that there's also the situations where, a power of attorney, an agent, executor, trustee might not be following the instructions of the estate plan or not really fulfilling their duties. How often does that happen? And I guess this is something that you could really go after, right?
Oh, absolutely. I mean, it happens. And, a lot of times in that scenario, certainly, the idea is to try to figure out what the intent was of the person who's actually the person who delegated the power to the agent, right? So at the end of the day, it's what was his or her wishes and what were their intentions and whether those intentions have been followed through. When you look at documents, there's a lot of different things you want to look at to see if they've been executed properly, right? So in terms of doing the analysis, certainly, are the wishes of the testator or the person who actually executed the documents or in whose names the documents were executed, are those persons' wishes being followed and observed, and were they the actual wishes that they had at the time the documents were prepared?
Gotcha. So let's kind of take it through. These are some of the reasons. We'll get into them a little bit deeper here and kind of break down what actually you can attack and how you would go about doing this as well. So let's start off with improper execution. What are you looking for here, and what are some of the things that maybe you can point to attack?
Well, okay. So, when you're looking at an estate plan, you have to first start to kind of look at, why you think there may be some issues with the estate plan that's been executed, right? So it starts with, was the person who signed the document under any kind of duress, were they being forced to do it? You typically see this in the context where, one child who, has been out of the parent's life for a long period of time, suddenly brings the parent to a lawyer to do a will, and takes one of the other children out of the will, or gives that particular child an extra benefit that probably was not the intention of the testator, right? So you look to see if you can establish whether there's been some sort of duress. You also may want to consider the testamentary capacity, or the ability for the person who executed the documents to formulate and understand what they were doing. Basically, that's the old sound mind and body test, right? That people have if anybody's ever watched a movie and watched will reading, did the person who signed the will, were they of sound mind and body when they signed it? And then you're looking at the formalities, the document execution, and how that was done, and we're going to be talking about that shortly. And then, like you said, the ability of an agent to sign documents. So those are that's the context of any kind of suspicions you may have about an estate plan. When it comes to execution, there are certain rules, and depending on the type of document, there are formalities that have to be executed in connection with the completion of a document. With a will in New York, the simplest standard is it must be executed in front of two witnesses who were present when the document was executed. And the witnesses have to attest to the fact that the person who signed the will was of sound mind and body. And they must sign in their respective presence, as well as the presence of the testator when the document is signed. Notarization, which is not something that happens on a will, but notarization does happen with regards to the affidavit that's typically executed by the witnesses who witness the will. And then you're looking for other indicia or other signs that the testator read and reviewed the document. So you're looking for initials in all the right spots and signatures in all the spots where they're supposed to be signed. Missing some of those items can be, pretty clear evidence that either the document wasn't executed properly or some other issue with the document itself.
I'm guessing as we go through all these things that you can challenge here, this has got to be the most clear cut, right? It seems to be pretty black and white.
Yeah, and that's absolutely, and that's definitely the one that you can look at the four corners of the specific document and kind of look at that as evidence of some sort of issue.
All right, let's talk about the mental capacity when this is maybe something that would raise suspicion about what state the person was in when they were doing the document. So what are you looking for here? What are some of the things that you can maybe point at the challenge?
Well, I mean, at the end of the day, what you're looking for is making sure that the person who executed the document did so freely, understanding full well, who their family members are, who their potential beneficiaries would be, the consequences of omitting or somehow curtailing, one person's share versus another, and then understanding, where their assets are, and being able to formulate a direction for how they want things to go. So it's really about understanding, it's about knowledge, and it's about being able to articulate that understanding.
Okay, and the burden of proof being a little bit more difficult there for that one. And then undue influence. So, did the person sign the plan do so under improper influence of someone else? I imagine this one's pretty difficult to prove.
Yeah, so mental capacity and undue influence are both difficult to prove, right? The burden is really high because obviously when you're challenging these documents, typically they're being challenged when the person's no longer around, so they're not around to establish it. So you're trying to provide it with in the case of capacity with medical evidence, which is not always is not always conclusive. And then with undue influence, it's really about the circumstances that came that came about when the person signed the documents, right? So who brought the person to the lawyer? Who paid for the plan being signed? What were the circumstances that arose that brought the person to the lawyer to get the documents executed? And then, what is the relationship between that person and the person who signed the documents? So, it's definitely a much harder thing to establish. And frankly, if you think about it a little bit, a person is more likely to be generous with someone who spends a lot of time with them. So that in and of itself isn't necessarily undue influence. So it's a difficult burden for sure.
That makes sense. All right, last thing here, the breach of fiduciary duty. What are you trying to attack here? What can you actually point to maybe have some substance and to maybe win some favor?
So this is the example of the corrupt accountant or lawyer or financial planner who gets in the head of the person who's signing documents and says, well, I can manage your money when you're gone. I can make sure everything goes to your estate the way you want to do it, or something of that nature. But really what they're after is just collecting the fees and managing the money and having control over the money, and essentially cutting everyone out if even possible, right? So at the end of the day, it's all about the motivations and self-interests of the fiduciary who's coming into play. So what you want to do in a scenario like that, if you're someone who's kind of vulnerable to that type of an arrangement, you want to be careful, and you want to create backstops and all kinds of checks and balances to make sure that that power isn't abused.
Well, anyone that is listening to this maybe has thought about this before, how to challenge an estate plan. So I guess for someone that's kind of thinking about this or has some concerns about an estate plan that maybe one of their loved ones has set up or crafted, what's that first step for them in terms of like reaching out to an estate planning attorney like you? What do they need to bring? What are you looking for when you first meet with them? Like, how does that first conversation go?
Well, I mean, the first thing we're looking for is the document itself, right? So we want to look to see if there's any of that clear-cut evidence to start, and if there isn't, then what is the basis for the allegations, right? So we're looking then at the breakdown of what's going on in the estate plan itself, right? So if it's a dispute, let's say between children, and everything's going equally to the children, it's going to be hard to overcome a plan like that, because it seems relatively fair, and it seems like that would be what most people would think of as an appropriate arrangement. But let's say you have an arrangement that's completely one-sided, where say there's 4 kids but only one kid's getting everything. Okay, well now that indicates there's a possibility that there may be some undue influence, perhaps, or what is the reason behind a plan like that. So then we start to delve a little deeper into the relationships, and who was around the testator when they were preparing the estate plan, what was the care arrangements, things of that nature. So kind of try to prove it try to prove the theory to start, and then we start kind of delving further into what kind of evidence we can use to establish any potential issues.
As for somebody that comes in there to meet with you too, I'm assuming you try to set realistic expectations, right? So if you feel, hey, maybe there's not a whole lot we can do here, or hey, I think you got a great case, either way, you're kind of having that upfront conversation with them before they try to pursue anything further.
Yeah, absolutely. It's important to be upfront, with that analysis, because it is a difficult burden. It doesn't happen very often that a challenge is successful. And then measuring success, in an all or nothing scenario, it's very hard to measure it, as a successful enterprise. So it is very difficult to do. The burden is very difficult, and the number one witness is not here. So that's really the biggest part of it, the biggest issue for sure.
All right, good stuff. Well, if you want to follow up, if you want to get some thoughts from Ted, have him examine your situation. Maybe there's an estate plan you want him to take a deeper look at, you can always contact him. alatsaslawfirm.com. That is the website. You can schedule a meeting there through the website. But if you prefer to do that over the phone, That option is also available at 718-233-2903. All right, good stuff, Ted. Thanks for taking us through this today. I know if anybody has questions about this, encourage them to call. Also encourage you to subscribe to the podcast as well if you haven't done that. Want to learn more about estate planning and some issues that you might face with your planning, you can always do that through the podcast. We appreciate your time as always, Ted.
Thank you, Ben. Great to talk to you.
All right.